morning, Your Honor. Good morning, everybody else assembled here today. My name is Evan Feinor. I'm staff attorney with Clean Wisconsin. It's my privilege to be here speaking today on behalf of Clean Wisconsin and its thousands of members throughout the state, as well as our co-petitioners, Sierra Club, League of Women Voters of Wisconsin, and 350 Wisconsin, represented by our co-counsel for Midwest Environmental Advocates. This case presents a fundamental, practical question. How much environmental harm and how much environmental risk is Wisconsin compelled to bear for Enbridge's desire to build a 41-mile oil pipeline? The answer to this question is provided by Wisconsin law. Wisconsin laws protecting our waters make clear that anyone who proposes to impact these waters must meet strong standards. And any plan purporting to show that these standards are met must be based on science and facts and evidence. The reason we have these strong standards is precisely because, frankly, for a long time we didn't. And we saw how poorly that went. We've had to learn the hard way what happens when you take about half of the state's historic wetlands off the landscape. Flooding, habitat loss, reduced water quality. We've seen what happens to sensitive groundwater-fed streams when you alter their flow. Loss of fisheries, loss of water quality. We've seen what happens when habitat for critical plants and animals is destroyed or overrun with invasive species. Loss of biodiversity and the threat of extinction or extirpation. Our past failures create an obligation to preserve what's left, best as we can for future generations. Because we better understand now how precious it all is, and that we can't afford to repeat the tragedies of the past. And that's what Wisconsin's law today aims to prevent. So now, anyone engaging in activities that will impact wetlands must show that their project is not going to result in significant adverse impacts to wetland functional values. Functional values are those things a wetland does that benefits people and the environment. These functional values include reducing the frequency and severity of floods, filtering water to improve water quality, and providing habitat for critical plants and animals. Anyone impacting surface waters in certain ways must show that they will not hurt the public interest in the proper functioning of those waters. That public interest includes the ability of all people to exercise their rights to use and enjoy these waters by fishing, swimming, paddling, and other activities. Projects can't violate the state's water quality standards for wetlands and waterways, and DNR cannot grant a water quality certification unless it has reasonable assurances these standards will be met. These water quality standards are there to ensure that our waters are clean enough to be usable for many of the activities and functions I just described, like swimming and fishing. And for all of these standards, DNR must have enough information and the right kind of information to determine these standards have been met before it can issue a permit allowing anyone to impact wetlands and waterways. Also, for a project of this magnitude, DNR must also put together what's called an environmental impact statement. This statement must carefully assess and discuss the environmental impacts of the proposal. It also gives the public an opportunity to weigh in with comments along the way. For this project, DNR received a lot of comments, including countless voices calling for protection of our waters from this project. The requirement to put together an adequate environmental impact statement is necessary to give the public confidence that major decisions are being made with all due consideration for the environmental effects. Now, these are great standards to have, but they don't mean much if we don't implement them fully and consistently. Enbridge comes into Wisconsin now with its eyes on building a 41-mile stretch of oil pipeline through and across a minimum of 186 wetlands and waterways, including some pretty special ones that mean a whole lot to a whole lot of people. Enbridge must meet the same standards as anyone else. Now, DNR ultimately decided they did and granted Enbridge permits to proceed with this project, but as we'll show later in this proceeding, this was a mistake. Enbridge never should have been granted these permits. Enbridge did not correctly assess the waters it will impact, understating both how many wetlands it will impact and the value of those wetlands. Enbridge does not have a comprehensive plan to avoid or limit impacts to Wisconsin waters from construction activities like trenching, blasting, sheet piling, horizontal direction of drilling, and many others. As our expert witnesses will show, these impacts include impairment of the hydrological functioning of wetlands, reductions in water quality, diminished habitat, and a wide range of other environmental harms that will both be long-lasting and extensive. These witnesses are scientists with decades of experience and expertise in hydrology, geology, blast engineering, water quality, and related fields. Enbridge also does not have an adequate plan for monitoring for impacts, so when things go wrong, and they will, they may not always know it. To make matters somehow even worse, Enbridge also does not have an adequate plan for fixing the problems it does detect, because its various restoration plans are flawed and lack critical information. So where would all this leave us? The degraded water is exactly the thing that Wisconsin's laws are designed to prevent. And this is to say nothing to the fact that this is an oil pipeline. An oil spill of any meaningful size could be catastrophic. Such a spill is far from outlandish given the proposed route's geology, steep slopes, erodible soils, and numerous other risks. Despite all of this, DNR issued the permits anyway. It knew about most of these problems and it should have known about the rest. It was aware of information gaps in the application that made it impossible to assess Enbridge's repeated assurances that all will be fine, that there won't be many impacts, and what impacts there are will be both minor and temporary. DNR knew Enbridge did not correctly identify and assess wetlands. DNR knew it lacked information to determine that the miles of blast Enbridge wanted to do to fracture bedrock would not result in permanent impacts in the environment, and so on and so on. Perhaps DNR thought it could make the best of a bad situation, to say yes to Enbridge's request, but insert enough conditions in the permits to paper over these deficiencies. But these conditions only reveal the many problems with this project. They do not solve any of them. At the end of the day, if we're going to be serious about properly applying Wisconsin's environmental law, there are things that DNR must say no to, and Enbridge's proposed oil pipeline was one of them. The permit conditions cannot rescue a proposal that simply does not meet the relevant legal standards. DNR's decision to issue these permits and grant these approvals must be reversed, and those permits and approvals invalidated. Thank you.